Okay. So with the power comes the ability to do certain things, and there is a certain level of discretion with powers that are vested in certain institutions, in certain individuals within a state. And this is a specific power within the state that we wish to divide. And separation of power is a very unique concept. It was first coined by Charles Louis II, Baron de la Montesquieu. So it's a very long French name. In his book, The Spirit des Louis, The Spirit of Laws, pardon my French pronunciation, was published in 1748. It is one of the most influential works because Baron de Montesquieu is known for his scientific approach rather than his own prejudices of approaching how the governments work. And he had a very inclination, a negative inclination of human nature. And therefore, he said something to the effect of what I will mention now about the British. A people like this, always in ferment, are more easily conducted by their passions than by reason, which never produced any great effect in the mind of the man. So he believed the conniving nature of human. He was not a believer in the Rossian sense that humans are there for good. They are for their selfish self-interest. And therefore, he postulated the idea of separation of powers. So separation of powers was not a limited concept per se. And separation of powers is not a simple factum that Montesquieu came up with, but it was specifically something that he observed and then he postulated this is how the things are. This was a fact that was implicit within the British system. Therefore, he observed, as being French, he observed the continental Europe, and he observed so many historical events and articulated his version of how and why they happened, the relation of power, government, and the people. And there are many influential writings of Baron de Montesquieu, other than separation of powers per se, for his scientific analysis of how the things work. So there's an important statement by Eric Brandt. He says, the separation of powers has been a central concept in the modern constitutionalism, and its primary purpose is to prevent the arbitrary government or tyranny which may arise from concentration of power. And relating to this, Lord Acton said, power tends to corrupt, and absolute power corrupts absolutely. Great men are almost always bad men. Therefore, we have to assume that if we give someone a certain level of power, a certain level of discretion, a person is more likely to abuse it. We cannot trust the person that the person will all magically be good, for that matter, seeing the human nature side of it. So therefore, we established, or from we, I mean the British established a system of balancing, a system of separation, a division, a checks and balances, which makes sure that the power that is vested to the people, that is entrusted by the people to the government, because the government, as famously Elon Musk recently said, that the government is an organization that have monopoly over violence. So that is one way to see that in a cynical way. One can say it serves many great purposes, but then again, there is this. So from the historical background, separation of powers is a unique idea. And it have its ties in the French Revolution. It have gained popularity all across the world. If you see the American system, the current constitutional system, the Civil War, all of them were in the effect controlled by these ideas, and these ideas were the governing thing that affected how they will make their idealist views of how the system should work, how the governments should work into a reality. So the influential intellectual theories that describe the ideal of separation of powers and the structural implementation and how it is envisioned to be implemented within the UK context. And there are obviously, with every type of theory, there is some challenges, some things that we can't go beyond. So there is one thing we will see in our book for that matter, and there will be some things in practice. So there is a dichotomy, let's just say, arguably within within the both the thesis that we do read, the things how they ought to be and how they are. So we will be discussing the philosophical justifications, the challenges, and how the UK have dealt with this in their practice of constitutional principles and their conventions henceforth. So the justification for separation of powers is embedded in what we call the doctrine of natural justice. And what does it mean when we refer to the word doctrine of natural justice? It is that things needs to be, in a sense, in line with our conception of what justice is. And there's an innate sense of justice amongst us. We have an idea, we have things that seems to us that are unjust by and large. So if we have to converge all the power to make laws, to implement them and adjudicate on the same, and enforcement and everything. So there's a very famous legal maxim that says, no one could be a judge of his own conscience. And therefore, if someone if someone is in effect trying to be the judge of his own conscience, for example, of his own concerns, it is not that we can trust that much power in a single individual, and therefore it needs to be separated because it opens a gateway to tyranny. So there's a tripartite theory by Montesquieu that separates the state into what we know as the legislature. Wait, some people are waiting. Let me add them. Okay. So there's the legislature, there's the judiciary, and there's the executive. And that is based on how the state have to function. That is a functionality-based division. And then there is a theory of Adam Tompkins, which is quite recent in the historical frame of reference. So his bipolar theory establishes the on the basis of authority, from where the authority is derived. One is from the people and one is from the monarch. So if we see the historical background of how the judiciary came to force, how the common law as we know it is common, how it evolved into the current state. So then we will see more reality to the theory of Adam Tompkins from a historical and power drawing basis. So legislature, since the Act of Settlement 1701, the people and Magna Carta, the evolution have led us into the current state of affairs in which we, wait, let me add those who haven't been able to enter. Okay. So establishes, so that is based on source of power, and that has somewhat legitimacy to it as well. But we have to see it from a functionality point of view, how the things ought to be, not how they are, because there's a very quite distinction between the both, which we need to be mindful of. So this is the tripartite theory that Montesquieu postulated, and which have gained very much popularity across many jurisdictions in the worldwide. So there is a clear demarcation of functionality within the legislative branch, the executive branch, and the judicial branch. The legislation's sole role, as I stated earlier, is to enact laws, to make laws possible, because with the change of time, there is always need to make new laws to adapt to those changes. Otherwise, the system would be too archaic, or could not keep pace with the needs of the time. And therefore, from the principles of democracy, as I believe it was Abraham Lincoln who said, government for the people, to the people, by the people. So therefore, people were given the power. In the times of the monarch before, we can see cases from 1601 in which they say that there are certain things even the monarch can't do. These are the things that are derived from the power of what we call it, God-given power, because the monarch was considered in the British pretext the shadow of God. The idea that was very common within the continental Europe, which changed with time. And how it changed, well, let's just say the French Revolution was one of the many revolutions, and we see its counterpart, the Glorious Revolution in Britannia, for that matter. So moving to the executive part, arm of the government, whose primary function is to administer the policy and the other functions of government. For example, we have government institutions for the military, the police, and there are electricity and other supply. Like we have companies, different providers, government-sponsored providers, their customs, their taxation, inland revenue. There's so many departments of the government which work under the directions of the legislature, obviously. So moving on, finally, the judiciary, as I explained earlier, it interprets the law of the land and resolves the dispute if it comes to that within people, within institutions, people and institutions, and so on and so forth, with its specific setup that have been built and evolved over the years, the principle of judicial precedent for that matter. So I will go into more detail into judicial precedent once we are discussing the judicial history of the UK. The judicial stance in pertaining to separation of powers. This is since as I mentioned earlier, historical fact, it's a factuality, the act of settlement. There were certain powers that were taken away from the crown because in the time of Tudor kings, things were very despotic, as Montesquieu have described form of governments. They are republican, and there are tyrannical. In tyrannical governments, there is tyranny. There is arbitrary use of power. So whenever the kings want, they do whatever they want. So that is the thing that we want to curtail. When we say we want to establish rule of law, we want to establish, and as a limb of, let's just say, rule of law, as a means of implementing the same, we have separation of powers, a unique idea in a sense. The judiciary, in this effect, the judicial system within the UK have endorsed the idea of separation of powers. For example, the law Diplock specifically asserted it in the case of Dupont Steels Limited versus Sears 1980. You can read the judgment for that matter. And he stated specifically that the British Constitution, though largely unwritten, is firmly based on the idea of separation of powers. Similar statement could also be seen in the cases of Baron Muirsworth versus Ministry of Justice 2011, RV Secretary of State, Home Department, ex parte, Fire Brigades Union 1995. So moving on to the CRA. One of the most, I will say, the best things that have ever been done within the constitutional reform of the UK is quite recent, a few decades ago. It would be hardly 2 decades ago. So CRA 2005, a decisive act of separation of powers. It was the first constitutional act in a long time, since we know that House of Lords, as we read the old judgments, it included House of Lords. So House of Lords was connected to the House of Commons. So it would, in effect, apply laws. It was part of the legislation. At the same time, it was providing a judicial role. So that was quite contrary to the principles of separation of powers. So the same person is adjudicating on the matter that he was entrusted to, legislate on. So he can make any law and make anything legal and illegal. Therefore, the powers of Lord Chancellor were curtailed. And very interesting is the development of how Lord Chancellor came to be Lord Chancellor. So in the ancient times, and here I'm moving to the evolution of what we call the common law. So the king used to decide things according to traditions of people within his realm. But at certain time, it was in time of, I believe, Prince William of Normandy, the first invader, let's just say it this way. He was also a French, by the way. So what happens is he cannot be everywhere. So he gave to his Lord Chancellor the ability to adjudicate on his behalf. So basically, in the start of the British history, the king was himself the judge, jury, everything, the legislator and whatnot. So it starts to, the power was delegated to the Lord Chancellor, and therefore Lord Chancellor was called the keeper of the conscience of the crown. And it is for this reason, from him, once he could not perform the task all on his own, the burden increased, there becomes started the court system that, as we see, it is evolved over a period of 1,000 years. So by CRA 2005, there was a strict separation of power, at least in terms of judicial capacity, the ability to exercise judicial authority. Supreme Court of the UK was established. Moving on to judicial independence. Now, we have to see the three arms of the government, or let's just say arms of the state, to be precise, because government means a very specific meaning within a specific context. So judicial independence means that the judiciary, in adjudicating on the laws that have been legislated by the parliament, are to be independent of all types of influence and have to decide by the book, without any undue